Hello, everyone. Good evening. This is Anish, and I'm here on behalf of the National Law Training Institute. Today, we have a very special guest among us, Arya, who got a very impressive All India rank of 87 in CLAT 2024 and an equally impressive rank of 83 in ALAT 2024. Arya, it would be great if you could turn on your video before we move into the session.
My video's on. Can you?
Yeah, we can see you now. Yeah. So, Arya, before we move into the session where you'll be sharing your ideal strategy for legal reasoning for CLAT 2025, we would want to know a little bit about you, your CLAT preparation. When did you start preparing? Which coaching were you enrolled in? How many mocks you gave? All these things, because we did not really get a chance to interact with you after the CLAT results. So, why don't you start and tell us a little bit about yourself and your CLAT preparation?
Okay. Thank you, Anish. So, hi everyone. I'm Arya. I'm from Chennai, and I secured All India rank 87 in CLAT 2024. So, I've been preparing for CLAT for I think 1 to 1.5 years. So, from the middle of 11th grade, I started preparing for CLAT. I gave CLAT 2023 just as a mock attempt, and that kind of helped me figure out where I was going wrong, what my weaker sections were, so that for my actual 2024 attempt, I would be able to work on those weaknesses. I enrolled in Shri Ram Law Academy. It was a coaching center in my city in Chennai. So I took offline classes, and I was also an NLTI mentee. So that was also
Yeah.
that also helped me a lot throughout the year whenever I had doubts and all those. And I think out of every section, my favorite was probably legal reasoning because the room for subjectivity was always lesser. So if you took logical, for example, then the person who was setting the paper, their impressions, their opinions, their biases would matter a lot more. But when it came to legal reasoning, all you had to do was you have to apply the principle to the facts that are given. So I think because of that, legal reasoning was always something that I enjoyed, and I always used to be excited, if there was a mock and there was a new legal concept that was given there. So yeah.
Right. So, Arya, if I heard you correctly, you gave a dummy attempt and that was CLAT 2023. So, what was your rank and score in that attempt that you gave, and how did you improve afterwards for your final attempt?
Okay, so in my dummy attempt, all I had done was like a little bit, I didn't know any GK. All I had
Hmm.
done was a little bit of like the reading sections, and like I tried to improve my reading. That was all I had done till then. So in December 2023, when I gave my attempt, that CLAT paper was actually a little difficult. Like the 2023 paper in general was,
Hmm.
the cutoffs were pretty low. It was kind of difficult for everyone. I mean, I obviously figured out that number one, I did not prepare GK. And so that made a big
Hmm.
difference. And also, I was taking too much time for the reading sections. So those are my main takeaways from my dummy attempt. And my rank, I think, was in the 900s or something like that.
Still not bad. Like, considering you had not done any GK
Yeah.
and your reading speed was also not up to the mark, 900 rank is still that a lot of people aim to achieve in their final attempt. Yeah.
When began my preparation for my actual attempt, my first thing was to improve my reading speed. And the second thing was obviously GK and all that. So, and I started giving mocks also that year. So I was able to
Yeah.
time myself and, improve there.
Right. Ara, also not being a little selfish here, but we'll also want to know about your experience with NLTI. So, how was it? If I remember correctly, you joined in very initial stage of last year. I think in January 2023, you joined us. So, how was your preparation journey throughout the 11 months that followed the time that you joined NLTI, and how did we make a difference, if any?
Okay, so NLTI was genuinely very helpful for me. So my mentor was Harshit. He got Air 4 in one of the years, 2021, something. So
Yeah.
yeah, so like initially, I was a little intimidated when I joined. I was like, oh, how would this work? their students, would they have the time to answer our doubts? Would this be
Hmm.
something consistent? And all of those are questions that I had in my mind. And throughout the 11 months that I took mentorship from NLTI, like every time I had a doubt, every time there was a session, like every session was helpful. There was always like a very prompt response to clear doubts, and there was also the atmosphere of studying with so many people who are in the same boat as you. So that was also helpful, and I made a lot of friends on Telegram and such, and I'm still in touch with some of those people.
Yeah.
So that was really nice, and there were some things that I wouldn't have had access to otherwise. One of my favorite parts of my NLTA experience was that we had this GK quiz, which Abhinav Somani Air won last year. He conducted those quizzes, and those are very interactive, and they really made GK prep a lot more interesting. So
Yeah. Right. Thank you so much for that, Arya. Uh, Ishani will be covering about all these things in the session. Please stay tuned. Arya will be covering about sources for legal and how do we go about legal reasoning. So Arya, over to you. Without wasting any more time, you can start with the session. If you have slides to present,
yeah.
please go ahead. Yeah.
Okay, thank you. Okay, guys, before I begin, just one thing. If anyone has any doubt or anything in the middle, and if I haven't covered it, then just please unmute and ask. So, all that is fine. I might not be able to see the chat box. So, you can just unmute and ask me, and I'll be happy to answer. Okay, I'll start presenting. Uh, can you guys see my screen?
Yes, it's visible.
Uh, Okay, so hi everyone. So today we'll just be covering legal reasoning, which I think is one of the most important sections for CLAT. And we'll be starting with the basics, and then at the end, I will answer some questions and solve a passage from this year's paper. So, okay, so this is the introduction to legal reasoning. So the thing with legal reasoning is you have passages of around 450 words each. I mean, plus or minus 50 words, it kind of depends. The main thing is you have to identify the principles, you have to infer, you have to understand, and you have to apply these principles to the given facts. So they'll make up fun names in the questions. The questions might be lengthy. That's one thing which differentiates legal reasoning from the other sections. So you have to have reading stamina and you have to have reading speed. So it has 28 to 32 questions, which is roughly 25% of the paper, and it usually has the most weightage out of all the sections. Prior legal knowledge is not required. So you don't have to be an expert, you don't have to mug up any case laws or anything like that. All you have to do is stick with what is given in the passage and apply the principles thereon. There is lesser room for subjectivity compared to other sections. Basically, that just means if say you have a logical reasoning passage, you would have to infer what the person who's setting the question is thinking. You would have to put yourself in their shoes, and you would have to answer the questions in that manner. The thing with legal reasoning, that it is more objective in the sense that only what is given in the passage is what you have to apply. So all that personal bias is kind of eliminated to some extent. And the legal reasoning questions in the actual CLAT papers usually have a wide variety of legal concepts. So that basically means you'd have your basics like torts, contracts, and all that. But you'd also have a lot of interesting passages from, say, family law, or something from IPC and all that. And the last thing is that legal reasoning usually includes cases which have appeared in the news recently. So, take something to do with internet shutdowns or electoral bonds, which are, very relevant right now. So, the passages are usually taken from newspaper explainers themselves, and, they're very relevant to what is actually going on today. So, a special reason why legal reasoning is important is that it is a tiebreaker. So what does that mean? Essentially, if you've scored the same mark as someone, say you've scored 100 marks and another person has also scored 100, but you've scored more in the legal reasoning section. So the legal reasoning section is the first thing that the consortium looks at while assigning ranks for people who've gotten the same mark. So say I've gotten the same mark as someone, but I scored 1 mark more in the legal reasoning section. That means the rank assigned to me would be higher. So legal reasoning is definitely extremely important for this reason, because like when you've come to the same mark, it becomes difficult to differentiate otherwise. So these are the sources and other basics that I used. So coaching material, I went to a coaching institute in my city, and every coaching institute offers kind of similar material. So you'd be given workbooks, you'd have sectional tests and mocks on your portals. And the thing with legal reasoning is that sectional tests can usually make a difference, like as in they would be more important compared to other sections, because the more you get exposed to legal concepts, say like every sectional test would have different concepts from different branches of law. So if you're familiar with these sections, it can actually make a big difference, and it can really help boost your confidence if you understand these. The next thing is frequently asked concepts like contracts and torts. So again, with the workbooks that your coaching institutes may have given, or just general Google search, you may be able to read up on basics like contracts and torts, which are frequent, which they frequently appear in mocks, and they also frequently appear in the CLAT paper. So it's good if you have a basic understanding of these concepts. You don't have to go too much in depth, you don't need to have prior knowledge per se, but if you just read up on these and you kind of understand how it works and you understand certain terms, it can really be helpful. The next is legal current affairs. So the thing with the legal reasoning section, like I mentioned earlier, is that you would often find that they pick up the passages from the newspaper. So they pick it, say, the Hindu or the Indian Express. So, since they pick up the passages from current legal news, it can be helpful if you can keep up with these. There are also websites like Live Law, Bar and Bench, but those, I mean, you don't need to buy a subscription. Those can be a little complicated. But just the general explainers in the Hindu and the Indian Express, when I would definitely recommend to keep up with them. Like if you right now the electoral bonds case is extremely important, so I mean you just find these appearing in the news frequently, so definitely keep a tab on those. And the final thing is landmark cases from the past. So I mean we might have all heard of famous cases like the Indra Sawhney judgment, or the Keshavananda Bharati case. So the thing with these is it's not a prerequisite to read them. You don't have to learn the judgment. You definitely don't have to read, 100, 200-page judgment or anything like that. But you could just look at the summaries of these cases, what went on in these cases, just to, build interest and for a basic understanding. Okay. The next thing I have here is some do's and don'ts while approaching the passages. One thing I want to make clear right now is these are approaches that have worked for me, and they need not necessarily work for everyone. If you're watching this in, I mean, April, or if you're watching this right now, then definitely you have some time to experiment. You have time to see what works for you and what doesn't. So you can keep these in mind, but definitely experiment a little bit and find out what works for you. So I've just segregated these into do's and don'ts. I'll start with the do's. So the first point I have here, I actually learned, from I think a topper interview. I'm not sure which one, but that is to keep underlining to a minimum. So this might be a little confusing, but it's actually very helpful and helped me increase my scores in the legal section when they plateaued. So why I've said this is, if you have a passage and you're just going, you're keeping a track, you're underlining every single thing that you think might be important, it can actually clutter your judgment. So if you go to a question and then you go back to the passage, you may find that you might not be able to identify where you actually have to look. So I think when it comes to underlining, you want to keep a tab on the dates for sure, like when a law came into effect. That is one. And also just the basic principle that is given. So that's basically all you have to underline. The next is understand the principles and break down definitions. So, one thing that the consortium really likes doing is that they give you a passage and then you'll have, a big fancy definition in quotes with big words. Many of those words aren't really relevant. And when you read the entire sentence at a stretch, it can actually be difficult to understand what's being said. So when you have a big sentence, like if you have, say a passage is given from the Consumer Protection Act, and you have, you have a definition of who a consumer is. It might be you're occupying a lot of space, it might be multiple words, but just break that down, maybe, use some brackets or something like that, and just try and understand what is being said instead of paying attention to every single detail that's given. The next do is pay attention to examples. So again, take the same example. If you're given a passage on the Consumer Protection Act, and you're given an example under the definition as to just explaining the principle itself, it can be helpful if you pay attention to this example, because you're seeing how the principle is actually being applied to the situation. So this is definitely something that should be kept in mind. The next important do is be mindful regarding the usages of and or. So this is a common place where people can get confused, or where the person who's setting the passage can try and trick you. So you'd want to keep in mind whether they've mentioned and or. Say you have, I'll get to this when I'm solving the passages, but and say you've been given voidable and void marriages, or you've been given voidable or void marriages. You'd want to make sure you differentiate between the usages of and or, so that you can apply the principle effectively. The next thing is to focus on the question that's been asked. Now, this might seem very basic. It's something that kind of applies to, across every section. But again, this is a common area where people usually go wrong, and I used to go wrong as well. So, a simple thing such as, paying attention to whether it says, which of the following is incorrect or which of the following is correct, you know, and things like that can really end up making a difference to your answer. And the final thing, again, it's something pretty basic. It's something that applies to every section. That is to go with your gut feeling. Now, it can be difficult to, really explain this, or to get in touch with your gut feeling. But basically, if you're confused between two options, but you don't want to leave the question unattempted, try and just go with your instinct. Just go with your first guess. Don't overthink too much. Don't spend too long on that question, and just go with your gut and hope that the answer is right. And a lot of the time you'll find that it is. So these were the do's. Now we'll approach the don'ts. The first don't, again, a common mistake that I used to make, a common mistake that all of us probably make, is don't let personal opinions influence your answers. So, for example, if there's a passage that's been given and it's, say, on same-sex marriages, as per the ruling, same-sex marriages are still not legalized in India. But my personal opinion might be different, right? And so, even if that's the case, you'd want to stick to the principles that have been given in the passage. You don't want to involve your personal beliefs. So, you want to try to stay as objective as possible while answering the questions. The next don't is do not panic if a question is slightly difficult or ambiguous. So, the thing with legal reasoning, like I mentioned earlier, you won't really have a problem of the author's opinion. You won't have that problem of subjectivity. At the same time, there might be options that are a little bit close together, or there might be questions that are a little vague. This happens every year, it happens with every section. So don't panic if a question is like this. Just take a deep breath, come back to that question later, attempt other questions. Just make sure you stay calm. The next don't is don't apply outside knowledge. Now, many of us, we might have been preparing for a long time. And you might have attempted many mocks, many sectionals, and all that. And obviously, that's going to practice will help you. At the same time, just be mindful to not apply the outside knowledge that you might have gained from this practice. So, if there's a passage on contracts and it says something that's contrary to what I might have read in a mock, or if the passage is slightly outdated and it mentions something different, don't apply your pre-existing outside knowledge. Just stick to what is given in the passage. And the next don't is don't fixate too much on background information. Another common pattern you'd find with legal reasoning is that you will be given, the various quotes that a judge may have said or that the Supreme Court may have said. You may find that the same phrases or the same principle is just being repeated in multiple words. So you don't, and that's kind of just to fill the word limit. So don't fixate too much on this. Just identify the principle, maybe, put that in brackets. The next thing is don't spend too long on a question. Again, this is a pretty basic thing that applies generally. But if a question is a little difficult, or if a question is a little ambiguous, and you've spent, say, a minute or a minute and a half on it and you still can't figure out the answer, just leave it. Either you don't attempt it or you attempt it later. It's very it's important to be able to differentiate between what questions can be attempted and what questions cannot. And the last thing, again, something pretty basic, is don't overthink and overanalyze. So, overthinking was my biggest enemy when it came to approaching a legal passage. If I found options that were a little close together, I would spend a very long time. I would, try and at some point, you will start thinking outside the scope of the passage. You wouldn't even realize, but you might end up doing that. So just keep overthinking to a minimum and make sure you go with your gut feeling. Here I've kind of just tried to pick up some frequently asked questions. If you guys have questions outside of this, you can obviously ask me as well. So the first question I have here is how much time should be allocated per passage? Now, this is something that differs for all of us. It is subjective, but personally, I believe that you should rather allocate time for the section rather than time per passage or per question. So, if you take legal reasoning and you have around 32 questions, I would ideally, based on my speed with other sections, I would ideally allocate around 30 to 40 minutes for the entire section. So this kind of gives you a broad framework to work with, rather than that constant pressure of, oh, I haven't completed this particular passage in 5 minutes. The time you take per passage will differ because every passage will be different. Some may be more lengthy than others. Some may have a difficult question. Some you may complete in very less time. So definitely allocate time for the section as a whole rather than per passage. The next question is, how are lengthy passages and difficult questions tackled? Now, again, this is something pretty basic that applies, just generally. So, the first thing is definitely stay calm, don't panic. If you've prepared and you find that a question is difficult, then it's highly likely that the question is difficult for everyone else around you. So, there's definitely no reason to panic for that. And the next is balance your time. So, going off of what I said for the previous question, say you've allocated 30 to 40 minutes for your legal reasoning section. And if the first passage was pretty easy and I had completed that within 5 minutes, then it's likely that I'll be able to allocate more time for the difficult passage. So I might be able to allocate, say, 6 minutes for this particular passage. And so just try and go with the flow and definitely keep that in mind. Once again, if there's a particular question that's difficult, you can leave it and you can come back and answer it later when your mind is a little clearer. The next is, should the passage be read first, or is it better to glance at the questions before going through the passage? Again, this is something that differs for everyone. It's something that's subjective. I personally used to look at the passage first and then answer the questions. I did that for, I think, every section. I used to refer back to the passage if there was something that I didn't pay too much attention to, or if there was something I wanted to be sure of, and that was when the minute underlinings would definitely help you. The next question is it sufficient if legal reasoning is practiced through mocks? Now, again, I personally used to use mocks a lot more than I did sectionals. But the good thing about legal reasoning is that sectionals can also be very helpful. So, the more familiar you get with a particular legal concept, the more repetitive it's going to be throughout your mocks and throughout your sectionals. You'd find that coaching institutes usually, they stick with pretty basic legal concepts throughout. And it's good if you get exposed to a lot of these and if you understand a lot of these. So, sectionals can also be very helpful. And the final question I have here is I consistently make mistakes with respect to a particular legal concept, or I do not understand the given passage. So, what can you do in this case? So, using a personal example here, I used to go wrong a lot with theft. So, if there was a legal passage on theft, they used to appear in NLTI marks too. I used to find that very difficult to understand for some reason, and I could not apply the principle correctly to the questions. So, what I did to tackle this was I would make sure to go after I completed the mock, that is, I would make sure to Google examples with respect to that particular law. So, for example, I would Google theft IPC examples, and a bunch of websites will pop up and you'd find these principles popping up and an example right under that. And a website here I've listed is Legal Service India, but there are a lot of websites that can help you with this. Another common mistake we make would be with respect to if you have the different degrees of murder. This was also a mistake I used to make if the murder was given in a passage. So for the same thing, I used to Google these examples and it would really help me. So this is kind of what I have. This is all I have for this. Next will be solving one passage. This is a passage from this year's paper. So this was a passage that I attempted, and it is a passage on family law. So again, like I mentioned earlier, a common pattern you'd find with legal reasoning is that you have concepts from a wide variety of laws. It's not just contracts or torts. You'd also find, say, international law. Family law is something that appears pretty often. And I chose this particular passage because while the paper I attempted was pretty easy, this was a passage where people did end up going wrong. So this is definitely so I thought I would just solve this for you guys. So I think we can begin. Okay. So the Supreme Court on September 1st held that a child born of a void or voidable marriage can inherit the parents' share in a joint Hindu family property. A key thing to note here is that it says void or voidable marriage. So this particular principle applies to both void and voidable marriages. A three-judge bench, headed by Chief Justice of India D.Y. Chandrachud, however, clarified that such a child would not be entitled to rights in or to the property of any other person in the family. So, all this means is that if a child is born of a void or voidable marriage, they would be entitled to rights in the property of the parents. It would not apply to any other family member. A voidable marriage is one that is made invalid by the husband or wife through decree. A void marriage is invalid at its very inception. So this difference should definitely be noted. And if you are attempting this passage, it would be something that you would underline. So a voidable marriage is something that becomes invalid after the marriage itself goes through. A void marriage is a marriage that is invalid from the start. So say child marriage, for example, is void from the start. Chief Justice Chandrachud said the first step to the inheritance of a child from a void or voidable marriage would be to ascertain the exact share of his parent in the ancestral property. This could be done by means of conducting a notional partition of the ancestral property and calculating how much of the property the parent would have got immediately before his death. Once the share of the deceased parent in this property is ascertained through such a notional partition, his heirs, including his children by means of void or voidable marriage, would be entitled to their portions in the share. So all this is saying is that you're basically conducting a hypothetical partition of the ancestral property, and you're ascertaining, or you're finding out what the share of the deceased parent in the property would be, and proceeding thereon. So it's a pretty simple concept, but they've kind of just added words, and they've kind of explained it in a manner that is not as clear. So to make sure you just break down the sentences and break down the particular words, like notional partition that is mentioned, just break that down and understand it like that. The Chief Justice said that Section 16 of the Hindu Marriage Act has statutorily conferred legitimacy to children born out of void or voidable marriages. In fact, Chief Justice Chandrachud pointed out that Section 16(3) stipulates that children from void and voidable marriages would have a right to their parents' property. The court said the intent of granting legitimacy to such children in the Hindu Marriage Act should also be reflected in the Hindu Succession Act, which governs inheritance. Children from void or voidable marriages come within the ambit of legitimate kinship and cannot be regarded as illegitimate by the Hindu Succession Act when it comes to inheritance. So, with this paragraph, a key point to note is the Hindu Succession Act, which is mentioned. The Hindu Succession Act is what governs inheritance, and this is a point which you could definitely be questioned on in the questions that follow. All this paragraph says is that children born out of void or voidable marriages. So so even including marriages that were illegitimate from the start, though the marriage might be illegitimate, the children themselves are not illegitimate, and the children themselves have a share in this in the parents' property. The case before the three-judge bench was focused on an amended provision in the Hindu Marriage Act. The case was referred to a larger bench in 2011 after a division bench of the Apex Court refused to follow past precedents and championed the cause of children born out of illegitimate marriages. With changing social norms of legitimacy in every society, including ours, what was illegitimate in the past may be legitimate today. The concept of legitimacy stems from social consensus, in the shaping of which various social groups play a vital role. Justice Ganguly, who authored the 2011 judgment, had observed. Now, with what is given in these two paragraphs, they aren't exactly essential. As in, it's kind of a quote that a judge has given, and it kind of just provides background information. It's not the principle itself. The principle itself is what was mentioned previously, and that is what your mind should be paying attention to. You can just glance over these quotes usually when you're reading a passage. During the hearings on the reference, Chief Justice Chandrachud had agreed with the division bench's findings that children from void and voidable marriages had rights over the property, whether self acquired or ancestral, of their parents. So, again, something key to note here is that it says whether self acquired or ancestral of their parents. This is definitely something that you would underline and you would pay attention to. So basically, all this means is that whether the property of the particular parent was self acquired, or whether it was purchased by the parents themselves, or whether it was passed down due to inheritance, regardless of this fact, the children would have rights in this particular property. So proceeding with the questions. This is the first question. As you can see, it is pretty lengthy. You find a lot of names, so just pay attention. Pay attention to who is who is related to who and those facts. Ashima and Ashok got married to each other in a traditional Hindu ceremony in Kolkata, after which they both moved to the USA, where Ashok had a job. In the USA, they had a child whom they named Gogol. So Ashima and Ashok have a child named Gogol. Many years later, Ashima found that Ashok was already married to Sushma before their wedding in Kolkata. Ashok and Sushma also had a child from their marriage, Arpita, who was older than Gogol by 4 years. Ashok explained to Ashima that although he had no intention of cheating on her, he had to keep his marriage to Sushma a secret, since his parents would have never agreed as Sushma belonged to a different caste. Ashima is shocked to learn that her marriage to Ashok is void as per Hindu marriage laws, since Ashok was already married before their wedding. She is trying to explore possibilities so that Gogol doesn't lose his inheritance from his father's side of the family. Based on your reading of the passage, what do you think is the correct position with respect to Gogol's inheritance rights? So, this is a very lengthy question, but the basic gist is that this man Ashok, he was already married earlier and he had a second marriage, which is not, which is, and this makes the second marriage void as per Hindu marriage laws, and he has children from both these marriages. The wife from the second marriage is trying to explore possibilities so that her child does not lose inheritance rights. So this is a pretty simple question. Even though it's lengthy, it just follows basic application of the principle that was given. Option A says Gogol could claim the entirety of Ashok's share of the ancestral property. Option B, Gogol would inherit the entire ancestral property as the only son of Ashok. So, if you look at the first two options, you can already kind of eliminate them. So, with option B specifically, it says Gogol would inherit the property as the only son of Ashok. Nowhere in the passage is it mentioned that only sons can inherit the property, and this option is very obviously out of the scope of the passage. Option C says Gogol would inherit his share from within Ashok's share of the full ancestral property without prejudice to the inheritance of other legal heirs, including Arpita. So this is the right answer, and this is a pretty basic answer. There's not much ambiguity with this question. Option D says only Sushma and Arpita are the rightful legal heirs of Ashok. Again, nowhere is it mentioned in the passage that only the spouses are the legal heirs. The entire passage is centered around the children themselves. So option D can also be eliminated easily, and option C is the answer. In the next question, in the above fact scenario, consider a property that was purchased by Ashok from his own earnings in the USA, thereby not making it part of ancestral property, but instead falling in the category of self acquired property. Upon Ashok's death, who would have inheritance rights over the said property? Now, a few things to note with this question. This was a question that people did find tricky compared to the others. So, the first important thing to note is that the property was purchased by Ashok from his own earnings, and it is self acquired property. But if you go back to the passage, in the last line, you would find that whether the passage is ancestral, whether the property is ancestral, or whether it was self acquired, regardless of that fact, the children would still be entitled to a share in that property. So, upon Ashok's death, who would have inheritance rights? The first option says Sushma and Ashima. The second option is Sushma, Ashima, Arpita, and Gogol, as they are all his rightful legal heirs. The third option says Sushma, Arpita, and Gogol. And the final option says Sushma and Arpita. So, we can easily rule out from among this. We definitely cannot rule out the children. The children do have inheritance rights, whether the marriage is void or voidable. So we can infer that Arpita and Gogol, both of them have inheritance rights. So options A and option D are automatically eliminated. Now, between B and C, option B says Sushma, Ashima, Arpita, and Gogol. And option C says Sushma, Arpita, and Gogol. Sushma was Ashok's first marriage, which means the marriage is valid. However, the marriage with Ashima is void since it was a second marriage. So we can infer that Ashima does not have legal rights over the inheritance. And so using this, we can say that Sushma, Arpita, and Gogol are the rightful legal heirs. So option C is correct. Now, coming to question 80. Based on your reading of the passage, how did the Hindu Marriage Act influence the outcome of the case on inheritance? Select one option from below. Option A says the amended provisions of the Hindu Marriage Act grant legitimacy to children from voidable marriages, and therefore this logic should be extended to children born of voidable and void marriages under the Hindu Succession Act. So this option does not seem incorrect at first glance, so let's keep this on standby. Option B says the amended provisions of the Hindu Marriage Act give legitimacy to the second marriage, and therefore this should also have an impact on the Hindu Succession Act. Now, this is clearly incorrect. Nowhere in the passage is it mentioned that the second marriage has legitimacy. If a person was already married and they have a second marriage, that makes the second marriage void. So we can easily eliminate option B. The third option says, the amended provisions of the Hindu Marriage Act grant legitimate status to children from void or voidable marriages and therefore should also extend to the Hindu Succession Act. Now, again, this appears correct. So let's leave it on standby. The final option D says the Hindu Marriage Act has no bearing on the case in question. So this again is obviously incorrect. If we go back to the passage, you'd see that both the Hindu Marriage Act and the Hindu Succession Act play a role in this case. So now that we've eliminated options B and D, let's look at A and C again. Option A says the amended provisions of the Hindu Marriage Act grant legitimacy to children from voidable marriages, and therefore this logic should be extended. What we should be paying attention to here is that it mentions only voidable marriages. Whereas if you go back to the passage, you'd find that both void and voidable marriages are mentioned. So because because void marriages are not mentioned in this option, and it is mentioned in option C, which says children from void or voidable marriages. So both key terms are mentioned here, and it's more all encompassing compared to option A. So in this case, option C is the correct answer. The next question is 12-year-old Kausalya was married off to 23-year-old Dashrath in her maternal home in Uttar Pradesh. She completed her education after her marriage and went on to get a job as a teacher at a government school. Dashrath's family, however, was opposed to her taking up a job outside the house and insisted that she should stay at home and look after her two sons, Ram and Lakshman. Kausalya, however, was very excited about starting her new job and sought advice from her younger sister Varshini, who was training to be a lawyer. Varshini advises her that since she was married before she turned 18, her marriage was voidable and she could get it annulled. Kausalya, who was not very happy in her marriage, considers this option but is worried that her sons may lose their inheritance. Select the option that denotes correctly the status of Ram and Lakshman to inherit their father's ancestral property. So, this again is a question that is pretty lengthy. It has so much background information that is not completely relevant to what is being asked. So, what we should be paying attention to here is that her marriage was voidable and she could get it annulled. So this is the basically the main sentence that you have to be paying attention to here. And Kausalya wants a solution as to whether her sons can get inheritance from their father's property or not. So when we look at the options, option A says Kausalya's children cannot inherit Dashrath's ancestral property, but can inherit his self-acquired property. Now, this is clearly incorrect because as per the passage, both self-acquired property and ancestral property come under the ambit of the Act. So we can rule out option A since the reasoning is flawed. Option B says both Ram and Lakshman can inherit their father's share of the ancestral property, irrespective of the voidable status of their parents' marriage. This is correct and exactly applies the principle that was given in the passage. But still, let's look at options C and D. Option C says if Kausalya decides to annul her voidable marriage, she and her sons would lose all rights of inheriting ancestral property from Dashrath. Once again, this is exactly the opposite of the principle that is mentioned in the passage and is clearly incorrect. So, even if she decides to annul her marriage, even if the marriage itself is no longer legitimate, the children are still legitimate and the children can still inherit ancestral property from either Kausalya or Dashrath. Option D says Ram and Lakshman can only inherit ancestral property from their mother's side since she decided to annul the voidable marriage. Once again, the children can inherit ancestral property from either one of the parents. So whether the mother or the father, there is no restriction placed on this. So option D is also incorrect. The next question. Ajay is married to two women, Diya and Riya, and both don't know of each other. He was married to Diya first when they were both around 23 years of age and studying together in college. They have no children. He later got married to Riya in a temple, and she had no idea about his first marriage with Diya. Ajay and Riya have two children, Raj and Rani. One day, Riya found out about Diya from one of Ajay's college friends. She wants to divorce Ajay, but finds out that her marriage to him is void since he was already married at the time. At a loss, she goes to a lawyer to find out about the rights of her children to inherit property, which is the most legally sound advice that the lawyer could give to her. So, this is a question again that has a lot of details and a lot of background information, but the basic principle is still repetitive. So, all you have to apply here is whether the marriage was void or voidable, the children still have inheritance rights. So, you have to look for an option that follows this principle. Option A says he would say that her children can still inherit property from Ajay thanks to the Supreme Court judgment. This is clearly correct and applies the principle to the T. But still, let's look at the other options. Option B says he would advise her to get her marriage registered so that they can inherit property. This is out of the scope of the passage, and nowhere is it mentioned that you have to register the second marriage, nor is it possible to do so. Option C says he would advise her to ignore her marriage with Ajay since it is anyway a void marriage. Now, this is definitely not sound legal advice. Even when you look at it at first glance, you can easily eliminate this option. But the question that has to be answered here is whether her children have rights in the property. So this definitely does not answer the question at hand either. And the final option says he would advise her to speak to Diya and sort it out with her so that her children can inherit property since she would have the final say. Once again, this is out of the scope of the passage, and this has no relation to the principle that is given in the passage. So, this is also something that can be eliminated. If you look at all these options as a whole, you can easily see that option A also has the most legal wordings and is definitely the most legally sound advice that a lawyer could give to her. Now we have the final two questions of this passage. So, question 83 says, in the above scenario, Ria wants to know if there is any way in which the judgment can come to her aid while inheriting property owned by Ajay. What would the correct position of law be? So again, this follows the same repetitive principle of whether Ria or the child has inheritance rights or not. Option A says no, she cannot inherit property, as the judgment merely talks about the rights of children from void marriages. Option B says, yes, she should fight for her rights to inherit property. Option C says, yes, Ajay would have to give her property since he cheated on her. Option D says she would get an equal share of property as Diya since they are both his wives who got married to him without knowing about each other. So, what differentiates this question from the previous questions is the previous question was centered around the inheritance rights of the children themselves. So, nowhere were the inheritance rights of the wives were not, or the spouses were not mentioned at all. This particular question asks about Ria, who was Ajay's second wife from the void marriage. This asks whether Ria has any rights in in the property. All the passage talks about is the inheritance rights of the children and not the inheritance rights of the spouse. So we can say that and option A clearly encompasses this principle, and all the other options can be eliminated. They also do not have any legal wordings or legally sound advice. Then the final question here is Srimati's first marriage was void due to being within the prohibited degree of relationship. Dhanalakshmi, who is the daughter of Srimati from her first marriage, confronts her mother once she finds her identity, demanding her share in her mother's ancestral property. Srimati, however, subsequently married Drupad and has two daughters with him, Ira and Shira, and is not interested in giving any property to Dhanalakshmi. Dhanalakshmi decides to assert her right in a court of law. How would Dhanalakshmi's share be determined? So, with this question, we can see that Dhanalakshmi already has rights. We can infer that Dhanalakshmi has rights in the particular property. Once you apply the principle as well, what it asks is how her share would be determined. So, this should immediately take your mind back to the point of notional partition. So option A says Dhanalakshmi would not have any right in her mother's share of the property since the right of inheritance pertains only to father's share of property. Once again, we can easily rule out this option as per the Supreme Court judgment, the children have rights in both parents' property. So mother or father, regardless, you have share in their property. Option B says Dhanalakshmi could demand a notional partition and get a share from Srimati's portion of her ancestral property. Now, this exactly applies the principle that was mentioned, and the particular phrasing, that is, notional partition, is also mentioned. So, this also seems like a legally sound option. Option C says being a child from a void marriage, Dhanalakshmi has no rights of inheritance. This is the exact opposite of what is mentioned in the passage and is clearly incorrect. Option D says it is Srimati's decision as to whom she gives rights in her property. Once again, as per the Supreme Court judgment, the Dhanalakshmi does have a right in her property, and option D does not answer the question that is given, which is how her share would be determined. So the key word here is notional partition, which is present in option B. So I think that's it for the sample passage. Do any of you have any questions?
Yeah, I have a doubt about attempting the passages.
Yeah, go
So,
ahead, please.
while we're attempting the legal aptitude section, what I found is
Hmm.
the passages are very lengthy and usually they're very dense, so you
Hmm.
can't really skim through it.
Hmm.
So, would you suggest maybe solving a passage or two and then moving over to a different section like GK, which won't take that much time, so you get a kind of a break and then come back to a passage?
Okay, so again, this is something that is pretty subjective. So, for me personally, I attempted the legal reasoning section after my GK. So, I would go in the order of English, GK, then legal. So, after a reading intensive section like English, I would have a break with GK, and then I would, get to the legal section. I personally never switched between sections. Like I didn't do a legal passage and then go to a quant or a GK or something like that. I feel like if you did that, you may make errors with the OMR marking. You'd have to be very careful with that. You can definitely experiment and see if it works for you, but I personally did not follow that approach. So if there was a dense passage or if there was a very lengthy passage, I would just make sure to break down the definitions and I would try to understand the principle that was given. So you'd find so much background information that's given. So just focus on what the question is asking.
Thanks. And just one last doubt.
Yeah.
I in my last two mocks, after analysis, I found out that most of the inaccuracy and negative marking I'm getting from the legal
Mm.
section is due to passages that relate to jurisprudence or philosophy or something related to that. So,
Mm.
how do I change that?
Okay, so whenever I had a problem with a particular concept. So I used to have struggle a lot with criminal law, like differentiating between different degrees of murder, for example. So what I used to do for that is after I completed the mock, I would just Google the name of that particular concept, and I would Google example along with it. So, for example, I would Google say. Degrees of murder examples IPC. So I would Google that and I would get a bunch of websites where like legal websites where they kind of explain the concept to you and they give you examples alongside so you can see how they're being applied. So that's something I used to do if I struggled with something. Maybe see if that works for you. Hello. I can't hear you. Can you?
I said that's it. Thank you.
Okay. Thank you so much. Good luck.
Yeah, thank you. Same to you.